pleadings. Order 6 Rule 1 clearly states that pleadings comprise of plaint or written statement. It does not even include replication. Then Rule 2 says that pleading to state material facts and not the evidence. Now, if I were to summarize a main body of a plaint, an ideal plaint as per me, the opening para after the nomenclature of a plaint should be like a preface to a book. It should give the crux of the entire pleading. The language should be very simple. Use of Oxfordian or Shakespearean language might get you an appreciation from the opposite counsel or your client, but it may be a hurdle for the judge to comprehend the case. Thereafter, I would say that after the introductory para, now you have to state the facts and do not miss on any of the details while getting the brief from the client. Sometimes in a rush of emotions, the clients tend to overlook or forget some facts. So be patient with them and be a good listener. Try to get the details. At the same time, include the relevant facts in the pleadings. No matter how much your client tries to pressurize, do not get the pleadings of two different causes of action mixed, or else you will end up leaving the judge confused. Now, what are relevant facts? Relevant facts are the one which tend to prove or disprove the existence of any other fact. Once the relevant facts are stated, then you have to proceed towards the legality of the provisions of law involved in the case. Now, see whether the essential ingredients are made out by the factual information provided in the said pleadings. Once that is accomplished, then you can formulate the legal paras of jurisdiction, cause of action, balance of convenience, court fees, etc. The prayer clause at the end is very important. Try to be very sure of what the client wants. In 99% of injunction suits I see as a defendant, the type of injunction mentioned is erroneous. Sometimes the legality of the document is challenged throughout the pleadings, but the relief of declaration is not sought by the plaintiff. Also see if there is an alternate remedy available to the plaintiff. So that is my guidelines for drafting any civil pleadings. Thereafter, while drafting an appeal, obviously the substantial question of law has to be seen. While drafting a review petition, it has to be seen whether there is an error apparent on the face of record. I guess that are the guidelines. Now I'm open to your questions.
Yes, Ali, are you there?
Thank you, sir. Yes, sir, I'm here.
Yes.
Uh, I'm audible?
Yes, yes.
You're audible but not
Sir,
visible.
yes, sir. I'm facing a small problem with my camera.
No
I'll be
problem.
asking the questions. Sir,
Okay.
I'll put my first question in front of you.
See,
What are the most common mistakes lawyers and the general public make when drafting civil documents, and how we can and how this can be avoided, sir?
look, as far as the general public is concerned, the first thing that they can do to avoid any kind of mistake is seek legal help. I'm saying it very candidly, but it is a hard fact that once if a person takes legal help, then he can minimize the mistakes to be done in a civil document. Now, we have to see whether a registration is mandatory for the document or not. We have to see whether there is a dispute resolution or not. There has to be a dispute resolution clause that is to be seen. It is very much seen that while accepting a loan from a bank or a NBFC, people tend to oversee the dispute resolution clause and thereafter they get entangled in the arbitration proceedings. So these are the things that need to be seen.
So, thank you, sir. And next question I want to ask: how can we ensure that our draft is precise, not comprehensive enough to cover all necessary legal points without overloading it with unnecessary details?
As I said, we have to concentrate on relevant facts.
Yes, sir.
Relevant facts are those which are necessary to prove an existence of another fact. As a student
Yes,
of
sir.
law, you would know what a fact is. So a necessary and relevant fact, if we stick to the relevant facts, obviously our draft will be more precise, yet comprehensive enough to cover all the legal points.
Okay, sir. Another question: what are some key precautions we should take while drafting civil pleadings to make sure that they align with legal standards and court expectations?
The key precautions to be seen is we have to use a very simple language.
Yes, sir.
The more technical and more difficult language that we use it tends to annoy the judges, and they are unable to comprehend what the client wants to put across through the civil drafting.
Yes, sir.
Yeah.
And next question: what are some key precautions we should take while drafting civil pleadings to make sure they align with legal
So I
standard and
guess
another
you have
question?
to
I think you
proceed
have
with.
answered this, sir.
Yeah,
Sorry
yeah.
for this. How can we effectively convey the facts and arguments in a way that is easy for judges to understand and is persuasive without being overly technical, sir?
Look, that again, my earlier answer to the previous question answers this question as well. Use of a very
Yes, sir.
simple language that can help us effectively convey the facts and arguments. Because the more technical and more legal language that we use, we cannot put judicial precedents in a pleading. We cannot put the legal ingredients of the section in a pleading, right? An
Yes, sir.
ideal plaintiff should only have the facts of the case. And the more simple the language, the more easier it is to comprehend.
True, sir. Sir, another question is next question is what role does clarity plays in drafting civil documents and how can we achieve clarity when dealing with the complex legal language and cases, sir?
Locally, when you say how can one achieve clarity while
Yes, sir.
dealing with complex legal language and cases, it can only be done with practice.
True, sir.
A, a lawyer will only gain through more and more practice. And as you would know, a saying goes that a young lawyer approach a very senior lawyer and asks, "Sir, how do I become a senior lawyer like you?" He said, "There are only three keywords to be done: read, read, and read." So the more you read
Yes,
the
sir.
files, the more you read the pleadings, the more you study the judicial precedents, and the more you practice drafting, that is how you learn. That is how you achieve clarity.
True, sir. So next question, what drafting techniques can we use to create an organized structure in our documents that guide the reader through and the argument and facts step by step, sir?
I think that I had replied to this question at the very inception of my initial speech, so to say. I'll
Yes, sir.
reiterate it again. The very opening line of the pleading should convey to the judge what you mean to convey by that drafting. The very opening line should summarize, it should put in a gist, it should put the crux of the matter to the judge. At the very opening line, he should know what you want to convey. Thereafter, you can proceed with the facts of the case and be as relevant and specific with the facts as you can. Thereafter, we have to see the legalities, the legal ingredients, if any are to be required to be mentioned, and then the prayer clause. And for the prayer clause also, we have to stick to the prayer which our client demands, what is required of the case. We cannot put two, three pairs of different causes of action in the same plaint. That
True,
again
sir.
causes confusion.
That's really informative, sir. From now, Charulata will lead the webinar. Thank you, sir.
Most
Hello,
welcome.
sir. I have a few of question. I would like to ask you, like, how important is the choice of language and tone in legal drafting, sir? Like, how we can ensure our language is professional or respectful or impactful while we draft?
Look, we have to choose the modest of words. You cannot be rude. You
Yes, sir.
cannot be harsh in your language while addressing the court or the opposite party. You
Yes,
have
sir.
to stick to parliamentary language, so to say.
Yeah.
And the yes, and the choice of language and tone will again come with practice. The more documents you draft, the more you study the files, That is how you learn.
Okay, sir. And what tips would you recommend for maintaining objectivity and focusing on the core issues of the case, sir, rather than becoming overly subjective or emotional on drafting?
Yes, we have to avoid all the impulsive reactions of our client,
Yes, sir.
because clients tend to sometimes go overboard with their emotions and even narrate to us such incidents which are not at all relevant to the case. But
True,
we
sir.
have to avoid such impulsive reactions. We do not have to put each and every word of the client to the pleading. We are not
Okay.
their mouthpieces. We have
Okay.
to exercise our discretion. We have
Okay.
to see what is relevant fact for the case, and
Okay, sir.
only those are to be mentioned.
Okay. Okay, sir. And how does strong drafting impact the presentation of a case in the court, sir? Like, how can an effective drafting can be an asset to advocates in advancing their client's interest?
Look, a strong drafting can very well impact the fate of the case,
Mhm.
because in higher courts, more so in high courts and honorable Supreme Court of India, the judges do not have time to listen, hear all the arguments on each and every matter. So basically, they are already apprised of the facts of the case through the pleadings,
Okay,
through
sir.
the drafting.
Mm.
A day before, they are apprised of each and every facts of the case or each and every case. So the more strong your drafting is, the more are your chances of winning the case.
Okay, sir. And my final question would be like, what review techniques or checklists can we use to ensure our documents are error-free, like logically consistent, and meet the high standards expected in civil law?
By documents, you mean the pleadings or other documents?
Like documents, sir.
Me, if you want to know only about the documents, that is documents like agreement to sell or power of attorneys or lease deeds.
Mm.
For that, the guidelines are different. Here also you have to see that the language should be as simple as possible, so that tomorrow, if there is a dispute, complications do not arise. Any of the clauses are not ambiguous in nature.
Okay, sir.
And then, as I said earlier, the dispute resolution clause has to be seen.
Yeah.
It has to be seen and interpreted. Whether
Yeah.
it should not be adverse to our client. And as far as the drafting is concerned, the guidelines would be use of very simple language. The summary of the drafting should be there in the opening para. The laws involved should be very minutely considered, and there should be no repetitions of the pleadings.
Okay,
None of
sir.
the facts or the legal precedents, and it should not be repeated in the foregoing paras.
Okay, sir. Okay, sir. Got it. Thank you very much, sir. That was very informative and valuable insights from your end. Thank you very much.
Any other question?
Guys, now the open mic is there. If anyone is having any questions, you can ask Saurabh sir.
Good evening, sir.
Very good
I'm
evening.
putting my question in front. What will
Yes.
be the AI role in drafting in future, sir? Will it going to take our places?
Okay, that's a very important question as of today, because AI is gaining importance every day. But the thing is, AI also has a limited database. Whatever is fed there, the results are bound to come from that fed database only. It is in
Okay, sir.
evolving stage, and I'm sure that in the near future, such apps would be there, would be devised, in which you put the facts of the case and you would get an excellent drafted case out of there.
Thank you, sir.
Right? I mean, if by AI we can still hear the voice of Kishore Kumar and Mohammad Rafi in an Arijit Singh song, so we can definitely get new pleadings out of the facts of a case through AI. But there is time for such a developed apps to come. As of now, I don't think AI can help which a human being can draft.
Okay, sir. Thank you, sir. Thank you so much.
If anybody have any questions, please be free to ask now.
Good evening, sir.
Very good evening.
Sir, my question is how to learn drafting from basics as a law student.
All right. Well, as a law student, you must study Order 6, as I said, because the essential ingredients of a pleading are mentioned in the Civil Procedure Code itself. Hello?
Yes, sir.
Yes. So once you study the essential ingredients of a plaint, of an appeal, of a review, of a revision, you would know the basics are the same. You have to begin with the nomenclature of the case. Then, as I said, the opening para should describe the gist of the case. Thereafter, you have to state the facts and then the law and prayer clause. In appeal, review, revision, it is slightly different. After the stating of the facts, the substantial question of law or the errors which are committed, which are apparent on the face of record and were erroneously done by the lower courts, that have to be pointed out before coming to the prayer clause. This is the difference.
Yes, sir.
Good evening, sir. Sir, do we need to? I just want to continue the same. Do we need
Yes.
to, uh, like, we need to give the reference for the case law in the same draft, or we need to put another draft for this?
Look, ideally, and as per the Civil Procedure Code, no judicial precedent should be mentioned in the pleadings. But with having a practical approach, I would advise you that sometimes you want to lay emphasis on a certain judicial precedent and you say that that is very important for the case and you do not want the honorable court to skip it. Then you shall always mention it in your pleading so that if tomorrow, even if the judges are unable to discuss the said judicial precedent, in a higher court, you can always point it out that, see, I had discussed this judgment in the lower court, but still it has been overlooked by that court.
Thank you so much, sir. Thank you so much.
Sir, one more question.
Yes, please.
Sir, what tools or softwares do you recommend for effective drafting?
Look, it is more of a you are more interested in the technical techie part of it rather than the drafting part of it. Look, Ramya is your name, right?
Yes, sir.
Yes, Ramya, you will have to do a little bit of hard work here. Only AI will not help you. You will have to put your efforts in the traditional manner of drafting. You will learn only if you inculcate that aptitude in yourself. Then you can have a better drafting. And AI can draft a pleading for you, but you should have the sense of what is good and what is bad.
Okay, sir. Thank you.
Brother, there is one question.
Yes, sir.
What are the factors to be considered while selecting a judgment as citation in a pleading?
Yes, sir.
That is Srividya has asked.
That is a very intelligent question, sir, because many various lawyers say that only such a judicial precedent should be cited where the facts of the case are exactly similar to the case at hand. But I do not concur with that point of view because in certain judgments, the point of law laid down is so important and it is exactly similar to the case at hand, but the facts of the case are slightly different.
Yes.
Like if we have a case of a landlord and tenant relationship and interpretation of a certain word or a term is required to be put before the court, but that interpretation can also be brought from another judicial precedent where the facts of the case may not be regarding a landlord and tenant relationship.
Correct.
Yes, sir.
And more so in pleadings, Srividya, you will not be focusing on citing a judgment. In
Yes.
pleadings, you are more focused on presenting your case.
Yes, sir.
During arguments, you give your judgment, citation, and all that gyan to the honorable judge so that they can see through point of law. And as brother rightly pointed out, it is point of law in the citation is more important than
The fact of,
comparison of facts and compatibility of facts.
yes, sir. Yes. Very true.
Yes, any other question? I think
Sir,
civil drafting people are not much interested.
excuse me, sir.
Yes, yes, please.
Sir, according to you, what is a perfect civil draft?
A perfect civil draft is which is drafted in the most simplest of the language. It puts across the facts of the case very easily to the whoever reads it, the judge, the opposite party, your own counsel, your client, and it only states the relevant facts and does not confuse the judge or any person reading it. That is the best draft.
Good evening, sir.
Good evening.
When we'll draft in a simple words or simple issue, simple manner,
Yes.
should we add the sections or general things, sir? General case law, or should we add in sections also?
Look, Miss Lakshmi, as per the Civil Procedure Code, ideally, neither the case laws nor the sections are to be mentioned in the pleadings.
Okay, sir.
Only the ingredients of the provision of law can be incorporated. That
Okay.
also with the help of the facts. We
Sir.
should not say that such and such section says this.
Huh. So,
Okay.
because by the sections means general people, they don't know about the sections, and they
Yes.
are not at all concerned about the sections, no, sir.
Yes. Yes.
That's why.
Yes.
So
No,
simple language means advocates language is different from simple language. No, we should write in a advocates language, no, sir, legal
yes,
language.
of course, we have to write in a legal language. All I
Huh.
am saying is we should not resort to a Shakespearean language.
Okay. everyone, everyone should
A
understand.
person who has a flair for English and is
Yeah,
a
yeah.
past, that is
They
what
should
I
not.
meant.
They should not keep the
Yeah,
dictionary in front
they
of
should
them.
not beautify the go into beautification
Exactly.
of the drafting. Yeah.
Exactly. They should not. They need not keep a dictionary before them.
Yes, certainly, certainly.
Exactly. Thank you so much, sir.
Gee, most welcome.
See, ultimately, the idea is judge should understand your case and give you a judgment which is applicable to the case. Now, if you give a task and homework to the judge, it is going to be difficult.
Yes.
Yes, yes, sir.
It is going to be
Exactly.
difficult. Already he
Yes,
has
sir.
so many cases on his board. No, we cannot add our grammatical effect on it.
Yes, sir. We need not show our total knowledge in front of them.
You should never show. You
Yes,
are
exactly.
asking something there. How can you show your talent there?
Yeah,
Yes,
there
sir.
are no bonuses for the extra.
Language,
Yes,
extra
yes,
language,
yes,
or
Perfect.
Oxford
That is
language.
true.
yes.
True,
Exactly.
true.
Thank you, sir.
Brother, I have one point of discussion.
Yes, sir.
Whenever we are writing cause of action in our cases,
Yes, sir.
I have seen nowadays people are elaborating cause of action without even checking relevances. Instead of saying for all further all subsequent dates when the cause of action
Yes, yes,
arose,
yes.
people are trying to elaborate it with dates. I have seen drafts where cause of action is running into 2 pages.
Yes, I
What
get your
is your
point.
take on
I get your
what is
point.
your take on it?
I get your point. You are saying that if a person has, if it is a suit for recovery, and there is a business transaction between A and B, and they have been doing business for 2 decades, so the cause of action would begin from since the 2 decades
2 decades.
to the current date. Yes, obviously that is a very wrong approach. The cause of action would begin only when the dispute arose.
Correct.
Yes, of course, that is there. That is a very wrong approach. No cause of action can begin from the very inception of time. So
Since
to say.
inception, I see people writing cause of action
Yes,
since
yes,
inception, and they
yes, sir.
also talk about the business transactions, payments in between. We fail to understand when actually cause of action arose.
Yes, sir. Even in writ petitions, say for a tender matter, I have seen brief synopsis of the list of dates, and they start from the inception of their company. In year 1990, the company was incorporated.
And
Or
the
say
certificate
in
of
19,
incorporation will be a document.
yes, and say in 1950, such and such Ministry of Agriculture was established, so and so, or the department was established, and they would begin the cause of action from there. But that is a very wrong approach. So I said that only relevant facts should be stated, and if relevant facts will be stated, the cause of action would also be curtailed to the date of when the dispute arose.
Very true. Very true.
Yes, sir.
That saves our time and judges'
Yes,
time also.
certainly.
Or else we will be struggling, and sometimes judge will talk about you explain me cause of action and maintainability. We'll unnecessarily waste time in discussing and submitting on that.
Yes, sir. But moreover, it also happens where the client is dominant over the lawyer. He doesn't understand his point of view. He only wants the lawyer to be a mouthpiece of the client. He says that I am approaching you only because you have a law degree. Otherwise, I would done the job myself. So, in such cases, the cause of action would begin since the inception of time. Yeah, but
Would
that
be
is a very
dictated
wrong
rather
approach.
than determined. No,
Yes,
at that time, cause of action would be dictated rather than determined.
yes, yes, sir. Very, very truly, very true, sir. Very rightly put.
Yes, sir. I think we have addressed the board. If there is any other person who has any questions, we would be very glad to address.
Yes, sir, I have a question.
Yes,
Please go
please.
ahead.
Can any person become a good advocate without good drafting by hiring a professional drafter, just like a stenographer?
Yes, look, practically there are people who are into such a practice, but I would never advise a young lawyer like you to adopt such a tactic, right? Because drafting is the key to your success as a lawyer, as a civil lawyer. I'm not talking of criminal practice. In a civil litigation practice, drafting is the key here. If you are not different from others, if you are not able to differently put your case before the judge, why should the client engage you? Should he not go to the other lawyers? The difference in your drafting makes you different from other people. A stenographer would have 100 drafts of the similar case on his computer or laptop, and he can just put the different names of the parties, and he can take a printout and give it to you. But that will not make you different from others. The difference is what matters.
Yes, sir. Thank you.
Most welcome.
That's a very interesting point where today people are depending upon teaming and working rather than
Yes,
exploring individual strengths.
yes, yes, sir.
Sir, actually, the thing is that everyone is getting a chat GPT and AI tools, everything, and they are guiding us to get the. Whenever we are opening any social media or something, it is popping up. For educates, we make these kind of tools and we'll make a draft and everything. So for the language purpose, legally, how as a beginner, we don't know how to get the legal language, exactly how we have to draft it. So for us, it is easy way. As you said, we need to do hard work. They are making us like dependent on the AI tool to get the draft done, and then we just need to submit. But I really appreciate the way you said that until unless we will not follow the basic things to learn, we'll not learn and we cannot be a good lawyer. If we want to be a good lawyer, definitely we need to draft by ourselves so that we know the case better than the others.
Yes, very well.
Thank you so much for this.
Yes. And you will also learn drafting more and more as you read your seniors' files, or you do your drafting yourself in a lot of matters. That is how you learn, na, in litigation practice.
Yes, sir. Yes, sir.
Any other query?
Sir, one question I got. Is
जी,
there a is there any difference in drafting in High Court, Supreme Court, and lower court, sir?
that that is a very novice question, I would say. But yes, there is a draft. There's a major difference in Honorable Supreme Court while drafting the SLPs. There's a prescribed format. You cannot go beyond that. There are basically certain columns to be filled, and the pleadings of the lower court are to be attached as annexure, and it is filed in the Honorable Supreme Court of India. Whereas in Honorable High Courts and District Courts, a lot of drafting is to be done. The substantial questions of law, the errors apparent on the face of record, that have to be pointed out. Questions of law have to be framed, which again have to be framed in an SLP. But there is a lot of, there is comparatively a lesser work to be done while drafting an SLP. Though people think that filing in the Honorable Supreme Court is far more difficult, but it is on the contrary a very easy task. The difficult job is in the trial court as well as in the high courts.
Yes, sir.
One Miss Shri Vidya has placed a request for me to share one of my drafts here.
We will share, brother. We'll share some basic drafts so that they can understand.
Yes, yes, certainly. Do you want me to do that right now?
If you have anything available which you can explore.
Yes, sir.
Well, I'm not very good with sharing on this uh, Google Meet, but I'll try. Is the document visible?
Yes, sir. Your screen is visible.
No, are you able to see the document that I'm sharing?
Not visible.
Sir.
Are you able to see the document now?
No, sir. Only the screen is available, but I can't see the document.
It's visible now, sir.
Okay, are you all able to see the document now?
Yeah, sir. Now we can.
Yes, sir. Yes, sir.
Well, I think this is I wasn't prepared for this, but this is a draft of a civil suit, which is now fixed for a judgment. Today only the final arguments were advanced in this case, so it has gone through the trial. And this is a civil suit for recovery of rupees 13,50,000. It is filed against the Institute of Chartered Accountant of India, as you can see. My client, which is the Cybex Support Services Private Limited, had put in a tender with the Institute of Chartered Accountant of India for uh, for placement of various workmen in the institute, and an amount of rupees 13,50,000 was deposited as a security deposit with the institute. Now the thing is, the institute had made all the payments of the bills, but they had forfeited the sum of rupees 13,50,000 arbitrarily, citing that since there are labor disputes pending with the workmen, so uh, uh, we will not return the amount, disperse the amount of the security deposit to you. Is that clear? Hello?
Yes, brother, they are saying they are able to hear. We have muted them so that
Okay. All right. So now, as you can see, the very opening para, as I said, it should summarize the case. The very opening para of the case is that the plaintiff, Messer Support Services so and so, is a private limited company with a vast experience of successfully supplying workforce and executing work orders of outsourced manpower for various government offices so and so. Mr. Varinder Singh Modi, director, is duly authorized to institute the present petition. Thereafter, the defendant is the statutory body for regulating the profession of chartered accountancy in India. That in the year so and so, the defendant had invited the tenders. So all the facts of the cases are stated till the date when the bank guarantee wasn't returned to my client. Look, in para 10, that after termination of the contract, Messer Cybex Support Services Private Limited had submitted the final bills with defendant institute, which were duly paid, but security deposit was not refunded to the plaintiff by the defendant institute without any rhyme or reason. That being perturbed by such an arbitrary behavior of the defendant institute, Messer Cybex Support, through its employees, contacted the defendant personally and sent several telephonic reminders for refunding the same, but to no avail. Copy of the emails are being filed herein. Defendant institute neither refunded the amount nor gave any reason for withholding of the said amount to the plaintiff company. Being aggrieved by the indifferent behavior, they filed an application under RTI, thereby seeking information regarding the reason. Despite an application, they did not disburse the amount. And thereafter, we had even filed an writ petition for the Honorable Delhi High Court. Para 20, that being aggrieved by the arbitrary behavior of the defendant institute, plaintiff had filed an arbitration petition under section 11. In the above said arbitration petition, the defendant institute suffered a statement that the dispute between the plaintiff and defendant was non-arbitrable, pursuant to which Honorable Delhi High Court was pleased to grant liberty to the plaintiff to withdraw the said petition with liberty to seek remedy before the appropriate forum. Thereafter, as per the Commercial Courts Act, we had filed an application under section 12A for mediation proceedings, where we were given a non-starter report. Now there is an amount of rupees 13,50,000 due and payable by the defendant institute to Cybex Support Services Private Limited, and also claims simple interest at the rate of 18% per annum. Hence this suit. Now the cause of action para begins. As was being discussed by my learned friend, Mr. Moksh, That cause of action for filing the present suit arose when the termination of the agreement had submitted the final bills. I have not begun the date of cause of action from the date the tender was awarded to me. I have begun the cause of action after the termination of the agreement, when I had submitted the final bills with the defendant institute, which were duly paid, but security deposit was not refunded. The cause of action also arose when the plaintiff institute before Honorable Delhi High Court in the arbitration petition suffered a statement that the dispute between plaintiff and defendant was non-arbitrable. It further arose when Honorable Delhi High Court was pleased to grant liberty to the plaintiff herein to withdraw the said arbitration petition with liberty to seek remedy before appropriate forum. Cause of action also arose in favor of plaintiffs and against defendant when pursuant to non-participation by the defendants in the mediation proceeding, non-starter report had been issued. The defendant institute is holding the security amount till date and has not refunded the same to the plaintiff. Therefore, the cause of action for filing the present suit is continuing and subsisting one. Hence this suit. So that is how a cause of action para is to be framed. Thereafter, there's the court fees para, and then the plaintiff and defendant reside and work for gain at Delhi, a registered office where the bid was submitted, letters, application under RTI, and correspondences were issued, and part of cause of action arose is situated within jurisdiction of this court. Payments were also received by the plaintiff within jurisdiction of this court. Hence, this honorable court has jurisdiction to try and entertain this suit. Then the prayer clause, since this is a suit for recovery, so we have prayed accordingly. Therefore, in view of the above and in the interest of justice, it is respectfully most prayed by the plaintiff that this honorable court may graciously be pleased to pass money decree for a sum of so and so along with future interest, then award the cost and so on and so forth.
Precise and brilliant.
So now you know the tricks of the trade.
Yes, sir. Thank you so much for your secret.
Yes.
Revealing the secret.
Yeah, you are most welcome, Shri Vidya.
That was such an amazing insight from your end, sir. Thank you very, very much.
You are most welcome.
Any
Thank you
other
very much for this.
I couldn't hear you.
any other question? I'm just asking.
Okay.
Thank you so much, sir.
Most
So
welcome.
I have one question here.
Yes, sir.
How is it different business case drafting or like what I've seen is in the uh, petition is it's a business case basically, but
Yes, it
when
is
it
a
comes to land
commercial suit. Yeah.
commercial,
Commercial court case, yes.
yeah. But in land cases and revenue cases,
Yes,
how
sir.
would you differentiate? Like, is there is a standard same or there should be difference between business and standard?
Look, the basics of drafting are the same. The only thing is that there is a Commercial Courts Act 2015 now in place. And as per the rules of the Commercial Courts Act, there are certain differences. Instead of the affidavit, there is a statement of truth now. There is an admission denial of the documents to be filed along with the suit itself. But otherwise, in all the civil drafting, the original documents have to be filed along with the plaint only. So the basics of the drafting are the same. There have to be facts of the case, cause of action, jurisdiction, all other parameters are the same.
Thank you, sir.
Yeah, most welcome.
Any other questions?
I think we are done with the time as well as the questions. We can call for the day, Jari.
Sir, kindly arrange us like give us a time so we will come and meet you as well in person. It will be very grateful.
आप कभी भी आइए, our doors are always open.
Can you
Sure,
share
sir.
your
Sir.
phone number or
Okay.
something, sir? Address or phone number?
We'll be in
Yes,
touch. We are
yes,
actually, sir, we are internees. Like we have just started a law. Okay, so we need a
yes,
guidance from you people like Dr. Moksha sir and
जी,
Surab
जी,
sir.
जी,
You are like
Exactly.
experienced person.
जी.
So we need to
Exactly.
have a guidelines from your end so that like you know some experienced person can teach us how to do, how to perform, and how to talk in front of the judge. What they want to
Exactly.
listen.
Look,
Exactly, we'll talk what they want to.
I can speak for me and my friend Mr. Moksh. We both are very encouraging and always open to discussion with young people like you.
Really true,
That
sir.
much, sir. It is more appreciated.
And as far as my contact details are there, Mr. Moksh has all the information. If you can ask him, he'll give you certainly.
Sir, where you
Sure.
reside, sir? Like both of you,
I
sir.
am based at Delhi.
Delhi. And
Oh,
sir, Moksha, sir, you?
We are in Hyderabad,
Okay,
place,
sir.
sir? Hyderabad. Place, sir?
Begumpet, madam.
Begumpet.
So Ali Heather, need to contact Ali Heather.
Sure, sir.
I think there is a feedback form which is being shared.
Yes,
If you
sir.
fill the form, we will share some information and insight about the session, and also we'll keep you
Okay,
in loop
I'll put
and
my
future sessions
contact
also.
details in the chat box for everyone to see.
Sure, sir. Sure, sir. Thank you so much.
I
Sure,
have
sir.
shared the feedback form in the chat box so everyone can just fill the form and
Sure.
please put valuable feedback on that. And sir, Saurabh sir, thank you very much. And it was like amazing talk over today. And
Most
my sister,
welcome.
thanks for the outstanding presentation you have, approaches for today's webinar, and your insights are like truly valuable. And we would really like to, have an opportunity to hear from you again in the future too, sir.
I'll be glad.
Thank you very much, sir, and thank you, Moksha, sir, for coordinating and doing this for us.
Okay. Once again, thank you so much, both of you, sir.
जी, most
Thanks for this
welcome.
informative session, sir. Really, we learned a lot regarding drafting, and we look forward for such webinars in future also, sir. Thanks a lot.
Most welcome.
Thank you, everyone. Have a good day.
Kindly fill the feedback form for sure. Thank you. Good night.
एक कुछ देखते रह रहा था, एक कुछ करते रह रहा था, कोई
Guys, section finished. Take care.